Good morning. Thank you all for joining us today. We are here for our first training of the Fair Housing and Tenant Rights training series. I am going to continue admitting people from the waiting room, and we'll start in a couple of minutes. So my name is Nicole Thomas. I'm going to be joined by my colleague Joy. We're both from home base. Really happy to see a lot of familiar faces and names, but to those who don't know us, Homebase is a technical assistance provider. We provide support to continuums of care across the Bay Area, and in Santa Clara County specifically, we work with the Office of Supportive Housing, and we put on and help organize a suite of annual trainings, with the Fair Housing and Tenant Rights training series being one of the most popular, well attended, and anticipated ones. So we're very happy to put this on today. Closed captioning will be available for everyone, and in a minute, I'll talk through some more Zoom tech features. So as I said, this is a training series. This is the first training today that will be covering tenant rights. Then on day 2, which is next week, we will have our training on fair housing, and day 3, it will be on eviction overview. All 3 days are going to be led by our 2 incredible co-presenters from Bay Area Legal Aid, and I'll let them both introduce themselves now, actually.
Hi, y'all. I'm Anna Ratner. I'm a housing attorney at Bay Area Legal Aid. I work out at the San Jose office.
And hi, everyone. My name is Laura Verwer. I am also a housing attorney in our Santa Clara County Regional Office located in San Jose.
Thank you. So I think we're all really well situated and familiar with Zoom right now, but to anyone who isn't, we are going to ask that everyone remains on mute for most of the training, just to minimize background noise. But there are going to be definitely moments and spaces during this training where we are going to leave space and make space for you to ask your questions directly. So if you prefer to come off of mute and it's easier for you to ask your questions that way, that's an option. We will be monitoring the chat box throughout, so please feel free to pop in your comments and questions there. Both Anna and Laura have left space during the training to answer questions, but we also want to know any questions that we don't have time to address today. We're definitely going to save those questions so we can follow up and provide you those answers at a later point. As I mentioned, closed captioning is available today. So if you would like that, you just need to go to the 3 dots with more, and then enable subtitles, or live transcription is what it should be called. And then you'll have subtitles. And if at any point you have tech issues that we can help troubleshoot and support. Okay, sorry, I'm seeing the request. Let me enable it. Okay, so you should now have the transcript. Please let me know if you're not seeing that. You can direct message me. And at any point, if you're having tech issues, feel free to direct message either Joy or myself, and we'd be happy to help you. So just to, another thing is we will be launching poll questions throughout the training. Those are completely anonymous. They're just an easy and quick way for us to make sure we're all on the same page, comprehension checks, see if we might need to revisit certain topics, and rephrase. So those poll questions will be launched throughout the training. And I think with that being said, for our quick icebreaker today, just to make sure you all know where the chat box is to start some of this today morning, we're going to ask that you share your name, organization, and then I just want to hear one thing you've done for yourself recently that's made you happy, that's made you smile.
Okay, I'll start. My name is Marcus Givens. I'm with Abode Services. I'm managing a brand new team of a brand new site here in Santa Clara. It's called Calabasas. And something that I've done recently is to buy something that I know is not good for me, but it tastes so good, and that's French toast.
Oh, love French toast. Thank you so much for sharing, Marcus.
So do I, more than I should.
Okay, thank you for starting us off, and please feel free. I'm seeing people pop it in the chat, so continue to pop it in the chat. We'll be reading them off and smiling for sure. Ooh, the beach in Carmel, gorgeous. Upcoming weekend in Tahoe. I'm so jealous, but so happy for all of you. Okay, so I'm going to stop sharing my screen right now and move over to the slide deck and let Anna and Laura take it away. So just 1 second.
Thanks, Nicole. And because more people have joined, we'll just introduce ourselves again. So my name is Laura. I'm a housing attorney in our Santa Clara County Regional Office at Bay Area Legal Aid.
And my name is Anna, and I am also a housing attorney at Bay Area Legal Aid in the same office.
And next slide, please. Like Nicole mentioned, we will cover a lot of topics in this training series. Today we'll cover tenants' rights. Next week we'll cover fair housing, and the following week we'll cover the eviction process. Next slide. So first, before we get into the substantive topics, we will provide an overview of Bay Area Legal Aid and our services and how people can become eligible to access our services and ways to access our services. And then we'll jump into the general overview of tenants' rights, including rental qualifications, habitability, criminal history, best practices to use, and a lot of protections for DV survivors with California law and also in federally subsidized housing. Next slide.
And just Bay Area Legal Aid is obviously a legal services organization. We provide free legal services to eligible low-income residents in the Bay Area. We cover all 7 counties, Alameda, Contra Costa, Marin, Napa, SF, San Mateo, and Santa Clara. I ran out of fingers. Yeah, sorry.
Yeah, and then some of the practice areas in Santa Clara County specifically include housing preservation and homeless prevention. Here we assist clients in addressing landlord-tenant matters, defending against illegal evictions, asserting their rights under fair housing laws and discriminatory housing practices. We also assist clients who have any issues with subsidized housing units like their Section 8 vouchers or any tax credit units. We also have an immigration practice area, which provides services to immigrant survivors of domestic violence. And such services include VAWA self-petitions and U visa petitions, as well as temporary restraining orders and other services. That's in conjunction with our domestic violence prevention practice. We also have a health consumer center, which assists clients with navigating services from public and private health insurance programs such as Medi-Cal, in-home support services, and other county health programs.
We also have a DV and sexual assault prevention practice where we assist with obtaining temporary restraining orders, divorces, child and spousal support orders, safe custody, and visitation orders. There's also our economic justice unit, which assists clients with obtaining access to or addressing wrongful terminations or denials relating to income support programs such as SSI, SSDI, general assistance, food stamps, CalWorks, etc. Our consumer law practice assists with a variety of consumer related cases, including fair credit reporting, fair debt collection practices, bankruptcy counseling, and advice. And our slightly understaffed youth justice program, although not forever, assists in areas including foster care, health access, SSI, education, housing, and homeless youth services.
All right, next slide, please. So with a Bay Area legal aid only provides legal services to eligible clients. To be eligible, clients must live in the counties that we serve, including Alameda, Contra Costa, Napa, Marin, Santa Clara, San Francisco, and San Mateo. Clients must also be either a citizen or eligible immigrant. So eligible immigrants include persons who have an application for permanent residency, who are permanent residents, any refugees, asylees, or immigrants that are a survivor of domestic violence, sexual assault, human trafficking, or other violent crime. And generally, income requirements are that clients have to be under 200% of the federal poverty line. There is an exception for our healthcare practice area, those calling in for advice or legal services as it relates to our health consumer center. There is no income eligibility. Next slide.
And in order to access our services, people with legal concerns can call our legal advice line, and that can be for any type of concern that we work with, or if they specifically have a health care access issue, they can call the Health Consumer Center, and the numbers are up here. Next slide, please. All right, first substantive topic, tenants' rights. Next slide. Yeah, there we go. Rental qualifications. Generally, landlords are allowed to require certain rental qualifications before renting a unit to a tenant. Each landlord is different. There will be different, qualification criteria depending on who your landlord is or prospective landlord is. Landlords generally request names of employers, previous landlords, and references. Landlords are also entitled to ask applicants to pay a fee so that the landlord can obtain a credit report. The law that establishes this was passed in '98, and the fee at that point was limited to $30, but does allow for adjustment in response to the consumer price index. I think currently the updated max for the credit report fee is about $50, but anyway. I was doing rental applications not that long ago, and I didn't see anyone ask $50, but they are entitled to ask up to that much. Landlords are entitled to refuse to accept an application, refuse to rent to a tenant, depending on their credit score. I'm getting a lot of echo. Is anyone else getting that? Okay, is that better?
I think it should be better now, maybe.
Thanks. Landlords can choose not to accept a tenant depending on their credit score, or if the tenant has an eviction on their record. If a tenant's credit score is not great, they can try to show proof of their ability to pay rent to the prospective landlord by showing evidence of past rent payments, timely rent payments, or proof of income. The landlord's not obligated to accept this alternative evidence, but some landlords are fine with that. So it's good to know. Next slide, please. Oh, you're still muted, Laura.
Oh, thank you. So now we'll talk about criminal history. Effective January 1 of 2020, there were new California regulations interpreting anti-discrimination laws, which prevents landlords from considering certain types of criminal history. So landlords cannot take any adverse action based on criminal history about any arrest that did not lead to a conviction or did not result in a conviction. Landlords may also not take any adverse action and refuse to rent to a tenant based on information about any referral to or participation in a pretrial or post-trial diversion program, or a deferred entry of judgment program. Landlords can also not take any adverse action based on information about any infraction or criminal conviction that was or has been sealed, dismissed, vacated, expunged, voided, invalidated, pardoned, or otherwise rendered inoperative by any judicial action or court order. Landlords also cannot take any adverse action or refuse to rent to a tenant based on information that was based on any like juvenile justice system information or adjudication. And lastly, housing providers can't implement a blanket ban on all applicants with a criminal history. So this includes doing a blanket ban on anyone with prior felonies, doing a blanket ban on anyone with a criminal history. The landlord does have to make sure that the criminal history is related to a legitimate risk that or concern of the landlord. Next slide, please. So housing, just to be clear, housing providers cannot access any criminal or civil records that are older than 7 years old. Landlords cannot ask or use information about arrests not leading to convictions. They cannot have these blanket bans, for example, no felons, in advertisements or otherwise exclude all individuals with criminal history. They cannot ask or use for anything about the any juvenile adjudications. And they cannot ask or use information about convictions that have been expunged. These other two prongs. So a landlord cannot deny someone based on a conviction or other criminal record that was a function of a disability. So here, we'll talk more about reasonable accommodations in our next training next week. But here's a situation where a tenant could ask for a reasonable accommodation for the landlord not to consider the criminal history if that criminal history was a function of a disability. There, the tenant could ask for a reasonable accommodation. So for example, if there was a tenant who had a disorderly conduct conviction, but that was based off of a mental health disability, that tenant could, and the tenant has thereafter sought treatment or maybe has gone to counseling or new medication and has changed and shown that it won't basically be a recurring problem in the future for the landlord to worry about, they can ask for reasonable accommodation. And then lastly, a landlord cannot deny someone on the basis of a conviction or other criminal records that relate to a history of experiencing domestic violence. For VAWA, which we'll talk about in later slides, VAWA applies to federally subsidized housing, and it's a protection under VAWA, and it could otherwise be potentially discriminatory under other fair housing laws. Next slide, thank you. So lastly, with criminal history, any housing provider who does obtain an investigative consumer report or criminal history information from a third party are also subject to requirements of applicable federal and state laws regarding those reports. So such as the Fair Credit Reporting Act, and housing providers are required to notify applicants if they take an adverse action partly or completely based on the information that they find in those reports. Other laws do include the California Consumer Credit Reporting Agencies Act and the California Investigative Consumer Reporting Agencies Act. Next slide.
Q&A, hypothetical. Do we have Nicole, do we have a polling function, or am I just, yeah, okay. A landlord, so I'm just gonna read the hypo and then you'll get the chance to answer. A landlord posts an advertisement for an available 1-bedroom unit. The advertisement specifically states, no individuals with criminal records. Is this permissible? I'm just gonna wait for people to. Anybody else want to answer? We've got about 2/3 of people responding.
I can, and while that is finishing, maybe we'll get more answers, but there was a question in the chat that said a property, just to clarify, a property manager can obtain a background check on a potential tenant and finds that that client has a felony, can they exclude them based on their criminal background? So the landlord does, if the felony is related to how the person could be as a tenant, and the landlord has a reasonable concern about that, the landlord can exclude them based on that criminal history. But what a landlord cannot do is implement a blanket ban on people with previous felonies and just not consider them as an applicant at all. You can kind of see this in advertisements on Craigslist where people are like, no felonies, yeah, and things like that. I wonder if that answers your question.
And on the same theme, everybody or most people have replied, and there's an overwhelming answer of no. The landlord may not put this statement in their advertisement, and no is the correct answer. The advertisement, they cannot put out an ad saying no individuals with criminal records. Hypo 2, very similar. Did I do that? A landlord posts an advertisement for an available 1-bedroom, and the advertisement specifically states no individuals with prior felonies. Is that advertisement permissible? And again, I'll just wait a minute. All right, about 2/3 of people have answered. Anyone else wanna chime in before we close the poll?
Oh, so sorry. I was too preemptive in closing the poll. So,
Oh, you closed it? It hasn't shown up on my thing. Anyway, I don't understand. This is my first Zoom presentation, so everybody please bear with me. Most people overwhelmingly answered no, and y'all are correct. No, the landlord may not advertise a unit and say no individuals with prior felonies. And I see, oh, well, I'll just say, just to be totally clear, blanket bans against any type of criminal history is prohibited, including a blanket ban on felonies. Someone posted in the chat that certain application forms include the question, has the applicant or any proposed occupant ever been convicted of or pleaded no contest to a felony? Now, I don't know the answer to the timeline question. If they say then when it is more than 7 years old, are they required to mark yes? I don't Laura, do you definitively know if they're required to mark yes? But I can say definitively the landlord can ask that question. They are allowed to consider criminal history. They are not allowed to blanket ban it.
Yeah, the look back period is limited to 7 years, I believe, but we can double check on that and get back with that specific question. That's a good question though, thank you.
Yeah, all right, next slide. Yes, you got it. Habitability is the next category of tenant rights and protections that we're going to discuss. In short, a landlord has a legal duty to provide a habitable unit. And this means basically that the rental unit is fit for occupation by human beings, and that it substantially complies with state and local building and health codes that materially affect tenants' health and safety. You know, to assess the facts of an individual case, the California Civil Code and the Health and Safety Code both have sections that explicitly address residential renters' habitability characteristics. I'm just going to summarize. Well, actually, okay. So what must a landlord do before renting a unit? The landlord must make the unit fit to live in or habitable. And during the tenancy, the landlord must repair problems that make the unit unfit to live in or uninhabitable. And some specific characteristics that make a unit habitable. Each rental unit must have a working toilet, a wash basin, which is, you know, old word for a sink, a bathtub or a shower, and the toilet and the shower area must be in a room that is both ventilated and allows privacy. A kitchen, the unit must have a kitchen sink that is not made of an absorbent material. And the unit must have natural lighting in every room through windows or skylights. And the windows in each room must be able to open at least halfway for ventilation, unless that room has a fan that provides mechanical ventilation. Every unit must also have safe fire exits or emergency exits that lead to the street or hallway. Stairs, hallways, and exits must be kept litter-free. Storage areas, garages, and basements must be kept free of combustible materials. Every entrance to a rental unit must have an operable deadbolt lock, and each window must have an operable lock or security device. There must be working smoke detectors in all units of a multi-unit building, e.g. a duplex or an apartment complex. And apartment complexes must additionally have smoke detectors in common stairwells. Every unit must also have a locking mailbox that's, you know, consistent with USPS standards for that type of housing's mailbox. And then the civil code also provides that in sort of a more general term of like repair and maintenance concerns, a unit must have the following in order to be habitable. This is going to be a list of like 8 things. It must have effective waterproofing and weather protection of the roof and exterior walls, including unbroken windows and doors. Plumbing must have plumbing facilities that are in good working order, including hot and cold running water. The appropriate parts of the plumbing must be connected to a sewage disposal system. The unit must have gas facilities that are in good working order, heating facilities also in good working order, an electric system that includes the lighting, wiring, and electrical equipment, all in good working order. The unit must have clean and sanitary buildings, grounds, and what the law calls appurtenances. For instance, a garden or like a detached garage. And those spaces must be free from debris, filth, rubbish, garbage, rodents, and vermin. The unit must also have adequate trash receptacles in good repair, and floors, stairways, and railings must also be in good repair. Next slide. What should a tenant do if repairs are needed or if the unit becomes uninhabitable? Tenants should give notice to their landlords immediately. And it is highly recommended that the notice be in writing, and that the tenant keep a copy of their notice for their records. If a tenant gives notice of a repair issue orally, like in a phone call or face-to-face, ideally the tenant would send a follow-up letter or email to the landlord saying, hey, just documenting what we talked about this morning. This is the repair that needs to happen. And again, keep a copy for their records. What if the problem is one that the tenant substantially caused? In that case, the tenant will likely be responsible for the cost of the repair. Tenant may also be responsible for the cost of a repair if the tenant substantially interferes with a landlord's ability to conduct repairs, like, I don't know, refuses to allow them to enter to do the repairs at, like, you know, for all of the times that the landlord proposes or something like that. If the landlord is notified of a repair and does not conduct a repair, there are a number of remedies available to the tenant of varying quality. The first is the tenant can contact code enforcement. If a repair is required and the landlord does not make the repair after a reasonable time, and after the tenant gave notice, a tenant can contact code enforcement. This is a government agency that can conduct investigations into health and safety and can mandate that the landlord complete repairs. Technically, a tenant can contact code enforcement at any time, but you know, for diplomatic reasons, it's better to try and get your landlord to fulfill their obligation in a direct manner first. The risks to code enforcement is that if the habitability issues at the unit are severe, code enforcement may red tag the property, which means the property must be vacated. This means the tenant will have to look for alternative housing. And it is always best to tell tenants about this possibility before you tell them to contact code enforcement. A landlord may be responsible for providing relocation assistance to the tenant if code enforcement red tags the property and they have to move. But in practice, it is hard to force the landlord to give you that money. And you may have to, the tenant may have to sue the landlord to get the relocation assistance. As long as like the issues aren't very severe to the unit, then code enforcement is a very helpful method of getting the repairs made. The next option available to tenants is the repair and deduct remedy. We do not recommend this in general because it results in a likely situation where, all right, I'll get to that when I get to that. This remedy, repair and deduct, allows a tenant to deduct money from their rent to pay for repairs or defects in the unit if the repairs would not cost more than 1 month's rent. A tenant may not use this remedy more than twice in any 12-month period. And a tenant may only use this remedy if the substandard conditions affect the tenant's health and safety and substantially breach the implied warranty of habitability. Furthermore, the tenant or their house, or their family or their guests or pets must not have caused the defects that require repair. And before doing repair and deduct, the tenant must first notify the landlord of the repairs that are needed and give the landlord a reasonable amount of time to conduct the repairs. And what is reasonable depends on the type of repair that the tenant is requesting. In general, 30 days is considered reasonable, but if, for example, your heater is broken in the dead of winter, a court might consider, just 2 or 3 days to be reasonable. So then after having gone through this process of informing the landlord, waiting a reasonable amount of time, if the landlord then does not conduct the repairs in that time, then you are entitled to do the repair yourself and deduct the cost from your rent, but not before that. So the risks of this method are that, first of all, it's not as fast as tenants want it to be, because you do have to wait kind of a long time for your landlord to not repair the thing you want them to repair. And second, it's hard to tell as a tenant in advance if the habitability issues are serious enough to justify using repair and deduct as a remedy in the eyes of a court. The landlord, if a landlord chooses to file an eviction action based on the payment of less than the lease amount of rent, the tenant could be evicted, right? They have to go and appear in court on an action where if they lose their home, right? And if they win, they get to keep, however many $100 of their rent. So the risk reward trade-off is not great. If a tenant has decided to pursue this particular remedy, it is crucial that the tenant document the defects in the unit with video, with photos. If they have conceivably medical evidence that a certain condition has harmed them, they should collect all of those documentation as soon as possible. And it is also crucial that they actually give notice to the landlord. Again, best practice is to give the notice in writing. Because of, yeah, I already said that part. The next remedy to a tenant if a landlord does not conduct repairs is abandonment. Instead of using repair and deduct, for instance, a tenant may abandon the unit. Again, like repair and deduct, the defects must be serious and directly related to the tenant's health and safety. The tenant or their household guests or pets must not have caused the defects. The tenant must inform the landlord of the repairs needed and give the landlord a reasonable amount of time to complete the repairs. And then if the repairs are not completed in that reasonable amount of time, the tenant may abandon the unit and will not be responsible for their rent set under the lease agreement. The risks of this remedy is that if the tenant misjudges how serious the defects are, if they don't affect the tenant's health and safety enough to justify the remedy, then the landlord may sue the tenant to collect the additional rent or damages of breaking a lease if there's a lease in place. And again, because of this risk, tenants should always document these defects and document the fact that they gave notice to the landlord of the defects. A fourth remedy available to landlords is available to tenants is withholding rent. A tenant can withhold some or all of the rent if the landlord does not fix serious defects that violate the implied warranty of habitability. Again, the defects must be substantial. They must be serious ones that threaten the tenant's health or safety. And as before, as in the other remedies that we've been talking about, The tenant can't have caused the defects. They must inform the landlord of them and give the landlord reasonable time to make the repairs. And then after all of those things have happened, the tenant can withhold some or all of the rent. If the landlord does this, God, why do I keep saying landlord? If the tenant withholds rent, the tenant should absolutely hold on to that extra money so that they have the full rent amount available, because the tenant may ultimately have to pay the landlord some or all of the withheld rent. The risks of this remedy are that, again, the defects may not be serious enough to warrant the remedy. And then if the tenant withholds the rent, the landlord may give the tenant a 3-day notice to pay or quit, an eviction notice. If the tenant does not pay in the requisite time, the landlord can then file an eviction action. And then again, the tenant will have to prove in court that the landlord violated the implied warranty of habitability. And if the tenant is unsuccessful in proving it, or if the judge just doesn't buy their argument, then the tenant will be evicted. And if the tenant does win and the judge agrees that the warranty was breached, the landlord will be ordered to make repairs, and the tenant will be ordered to pay what the judge determines to be a reasonable rent amount. This order of how much rent must be paid in the court's judgment, tenants will have to pay that amount within 5 days, sometimes less. Wait, no, within 5 days. And so that's why a tenant absolutely wants to have that money ready, because you don't know if the judge is going to agree with your exact assessment of lost value. And if the tenant does not pay that, then again, they will be evicted, even though the court agreed that the warranty was breached. As with all of these these remedies, tenants that are considering pursuing them should carefully document all the defects through as many mediums as they can, and have evidence of the notice that they provided to the landlord. And the final remedy is a tenant may file a lawsuit for the breach of implied warranty of habitability and or for constructive eviction. If the damages claimed are less than $10,000, the tenant can file this in small claims court. If the damages claimed are more than $10,000, the tenant can file in superior court. Next slide.
And just to jump in here, I see the questions in the chat. We are providing general information and can't really get into specific advice for specific legal questions. We can just provide general information. So just want to make that clear. So sorry if we don't answer your question that pertains to a specific set of facts. But tenants can always contact our legal advice line for advice or assistance.
Best practices of tenants and landlords. The duty of good faith and fair dealing is biggie. Parties have the obligation to engage in this in good faith and fair dealing, and they cannot unreasonably interfere with the right of the other party to receive the benefits of the agreement. For instance, a landlord may not fail to make a repair simply because a tenant paid rent late in the past. Or on the other hand, a tenant cannot pay rent late on purpose just because they did not like the way a landlord handled some particular situation. The next best practice category is to inspect the unit before you move in, before a tenant moves in, and upon moving in, thoroughly inspect the unit. And before you move out, the tenant should document the condition of the premises with pictures and videos. It's very important for tenants to document what the unit looked like before move-in and upon move out, so that they have evidence that is in roughly the same condition, or at any rate evidence of the exact conditions that they were given and then left. Landlords will do close inspections of the unit to determine how much of the security deposit they should retain to fix any issues that were beyond normal wear and tear. For tenants to ensure that they receive their security deposit back, they should clean the unit to the condition it was in upon move-in. And again, document. And if on the other hand, a tenant leaves the unit with trash or debris everywhere, or broken items around that they didn't inform the landlord about, when those conditions first occurred, then they will likely, the landlord will withhold some of their security deposit. Best practice, communicate. One of the most onerous best practices, frankly. Communication is key in avoiding and resolving most problems, but it can be stressful, which is why sometimes people don't do it. All communications, especially any requests or agreements, should be made in writing. And a writing that the tenant has their own copy of. Landlords and tenants are expected to communicate with each other on relevant issues like repairs or rent. So you won't get to sort of use any of those repair remedies really if you never tell the landlord that the repairs are necessary. And that kind of goes for any most tenant remedies. Finally, best practice is, as a tenant, to pay your rent on time. If you can, pay by money order or check. The slide says if paying by cash, you should obtain a receipt for the payment and keep that for your records. That is absolutely true. I honestly think that even if you're paying by money order, you should try and get a receipt for it. Because on a receipt, you can say, for March rent, right? And then the landlord can't then apply that to some late fee and then later allege that you didn't pay March rent because they took some of the money for some other debt. So you want to be able to document what the payment is for and have evidence of that for your records. Next slide, please.
So now we will do another hypo. So the hypo is that Tammy tenant has a rental agreement where she agrees to pay $1,000 in rent. A year into her tenancy, she has a roach infestation in her unit. She verbally told her landlord. Landlord immediately contacted pest control. Pest control came and eradicated the roaches. 6 months later, Tammy notices roaches and ants in her kitchen. She does not tell her landlord and withholds rent for the month. So what best practices should Tammy have done? Looks about 60% have voted. they started to kind of trickle off. We can unfold. So most of you guys got that correct. It was kind of a trick question. All of the above is the correct answer. It's best practice for Tammy to provide a notice in writing once she notices that the pest came back. She should have informed her landlord that the habitability issue started again, and also take pictures of the habitability unit. So it's always good to document with pictures or video. So good job. And then the next question is a true or false. If Tammy's landlord files an eviction action, Tammy should assert habitability as a defense. All right, just a few more seconds. Get your answers in. All right. So yes, the correct answer is true. Majority of you guys got that correct. It is a little tricky since here Tammy may not win on a habitability defense because she didn't provide notice to her landlord, but she should still assert it anyways. We will again go over the eviction process in part 3 of the training, but just wanted to put that in here since we're talking about habitability. And when using those remedies that Anna discussed earlier, it is really important for tenants to assert themselves of their rights and provide notice if they are using the remedy of withholding rent or repair and deduct. Right, next slide.
All right, now we're going to discuss the Violence Against Women Act. Oh, okay, well, also known as VAWA, and the protections of this act as they relate to housing. All right, next slide. Sorry, Nicole. VAWA is intended to encourage survivors who are receiving federal housing subsidies, to report and seek help for the abuse that is committed against them without being afraid of eviction. Public housing agencies and landlords of covered federally assisted housing have special duties under VAWA when renting to tenants who are domestic violence survivors. VAWA protects individuals from being discriminated against because of acts of domestic violence, sexual assault, dating violence, and stalking committed against them. And it does apply to survivors regardless of sex, gender identity, or sexual orientation. Again, VAWA does not apply to private housing. It just applies to federal housing programs. Next slide. This is just the programs that are covered under VAWA, the federal housing programs. It includes housing through HUD, through the Department of Agriculture, and through the Department of Treasury. As you can see, public housing, Section 8 vouchers, project-based Section 8, and low-income housing tax credit units are all programs that are covered under VAWA. Next slide. VAWA covers persons who are subject to the following. And this is just sort of definitions of the kind of conduct that VAWA is trying to protect against. Domestic violence. Victims of domestic violence are protected under VAWA, and domestic violence is any felony or misdemeanor crimes of violence committed by a current or former spouse or intimate partner, a person with whom the victim shares a child, a person who is or has lived with the victim, and any person against whom the victim is protected from certain types of acts under state or local domestic and family violence laws. Dating violence is violence committed by a person who was or is in a social relationship of an intimate nature with the victim. There are 3 factors that are used to consider the nature of the relationship: the length of the relationship, the type of relationship, and the frequency of interaction between the persons involved in the relationship. Survivors of sexual assault are protected under VAWA, and sexual assault is defined as any non-consensual sexual act that is prohibited by law. And stalking is defined as any conduct directed towards a specific person that would cause a reasonable person to fear for their safety or suffer substantial distress. VAWA protections apply to both applicants and to tenants. Tenant here does mean person on the lease. So it doesn't include guests, it doesn't include unreported household members. Yeah. Next slide, please.
Yeah, so next, I saw in the chat, there's a question about eviction protections, which we'll cover right now. So VAWA does provide survivors of domestic violence with protection from eviction. So generally, a person cannot be denied housing or assistance based solely on criminal activity that is the basis or direct result as their status as a survivor. This includes any adverse factors resulting from the abuse. For example, if there was a criminal history that was related to the abuse. Just the question, thank you, Kimberly, for in the chat clarifying can still evict for other reasons. So VAWA does provide this protection if the eviction is solely based on their status as a survivor. An incident of domestic violence cannot be considered a serious or repeated lease violation by the survivor, or cannot be good cause for evicting the survivor. There is an exception to this protection, and housing providers can still evict or terminate assistance due to an actual or imminent threat to other tenants or employees if the survivor is not evicted. But what is an actual or imminent threat is defined as a physical danger that is real, that would occur within an immediate time frame and could result in death or serious bodily harm. In determining whether an individual would pose an actual and imminent threat, the factors to be considered include the duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm will occur, and the length of time before the potential harm would occur. So eviction should be a last resort. Housing providers can offer other protections, including transferring the survivor to another unit, involving law enforcement to keep the abuser off the premises, seeking other legal remedies to keep the abuser off the premises. So eviction should only occur if there's no other action that can be taken that would reduce or eliminate the threat. And also restrictions predicated on public safety cannot be based on any stereotypes, but must be tailored to the particularized concerns about the individual residents and make an individualized assessment. So next slide, please. The next protection that VAWA allows is also removing the abuser. So a public housing authority or a landlord can do what's called bifurcate or split a lease to evict the DV abuser while allowing the survivor to remain in the unit. So survivors of domestic violence who wish to remain in the unit can make this request to their landlord. The remaining tenant does have the obligation to establish eligibility. Again, VAWA only applies to federally subsidized housing programs that have eligibility criteria. And the remaining tenant should have at least 90 days or until the lease expires with a possible 60-day extension to establish eligibility for the program. Or if they're not eligible, find alternative housing. It's also important to note that landlords who do try to remove the abuser must still follow federal, state, and local laws with the eviction process. Next slide, please. So now we'll just cover documentation options that survivors have. Survivors have multiple ways to document the abuse to get afforded the protections under VAWA. So first, they can use the self-certification form. That's a HUD form. It's HUD form 5382. They can also use a police, court, or administrative order as documentation, or they can use documentation from a third party. So for example, a nonprofit organization that assists domestic violence survivors, a statement from that type of organization would satisfy the documentation. And also if a survivor doesn't use any of those three methods, they can use any other type of evidence that they can, but the housing provider does have discretion whether or not to use that documentation. It's always best to, the self-certification form is the easiest way where a survivor just can self-certify the abuse that they faced. Next slide, please. So now we're going to talk about notice rights. So many people are in, many participants in housing programs are sometimes unaware of the rights and protections that they have and are entitled to under the law. So it is really important to stress the right to this notice. And a housing provider must provide the HUD notice of VAWA occupancy rights as well as a self-certification form to applicants and tenants, either at the time an applicant is denied admission or assistance, at the time an individual is admitted or given assistance, and with any notification of eviction or termination of assistance. Existing tenants must also be provided with the VAWA notice and self-certification form. They can receive it during the annual recertification or lease renewal process or at any other time. So HUD has developed a standard VAWA occupancy form. It's form 5380. If you Google that, you can find the form, and it's also available in 14 other languages. So just to answer the question in the chat, HUD has it on their website, the HUD 5380 form. Next slide, please. Next, we'll talk about emergency transfers. So another right that VAWA provides for survivors is the right to an emergency transfer so that the survivor can transfer to a safe environment. Emergency transfers are crucial for survivors in finding safe and affordable housing. So covered housing providers do have the obligation to develop an emergency transfer plan to coordinate emergency transfers. A survivor is eligible for an emergency transfer when they expressly request the transfer and they reasonably believe that they are threatened with imminent harm from further violence if they remain in their current place or residence, or if the survivor has been sexually assaulted on the premises within 90 days of the request. Or longer if the housing provider provides a longer timeline. So housing providers may process the emergency transfer requests that are not in writing as long as the survivor makes a verbal statement requesting the transfer and express request for that emergency transfer. Also, emergency transfer requirements do not supersede eligibility or other occupancy requirements. So again, VAWA does relate to federally subsidized housing programs. This means that the survivor must still be eligible for the covered housing program on their own. For survivors who do request external transfers, which are generally transfers that require an application to another program, the emergency transfer plan must provide measures to assist these tenants. Next slide, please. So now we'll talk about confidentiality. VAWA confidentiality is very important to stress because, you know, a lot of survivors are afraid to come forward and report abuse or assert their rights. So it is important to note that their information will be protected. So any information that is submitted by a survivor under VAWA must be maintained in strict confidence. Housing providers cannot allow anyone administering assistance or employees to have access to the confidential information unless they're explicitly authorized. And confidential information must not be entered into any shared databases or disclosed to others, only if that disclosure is requested and consented to in writing by the survivor in a time-limited release, required for use in an eviction or termination hearing, or if it was otherwise required by law. Next slide, please.
Hypothetical for y'all. Tim Tenant is a survivor of domestic violence and wants to assert VAWA protections and request an emergency transfer. True or false? Tim Tenant cannot request an emergency transfer because VAWA only applies to women. Right. We've got about 60% of people answering, and the vast majority say false. That is correct. VAWA protections are available regardless of the survivor's sex, gender identity, or sexual orientation. Next slide, please. California law is protecting domestic violence survivors. So just to be clear, these are laws that apply to all housing providers in all of California, whereas the VAWA ones were just for federally subsidized units. All right, California has several laws that help domestic violence survivors maintain their safety in housing. They have the right to have the locks changed. They have the right to break the lease. They have a right to protection from eviction. And the housing provider has a duty to provide safe housing. Next slide, please. So for the right to have locks changed, a survivor of domestic violence can mandate that their landlord or property manager change the locks on their unit if the abuser is a tenant, or even if the abuser is not a tenant. How the DV survivor goes about doing this changes a little depending on whether the abuser is or is not a tenant. So if the abuser is a tenant, a survivor must provide a copy of a court order that excludes the abuser from the home and make a request in writing to the landlord that the landlord change the locks. The court order can be a temporary restraining order, or it can be a protective order. And it must have been, the order must be dated within the past 180 days of the lock change request. But upon receiving both the proper court order and the written request for lock change, the landlord has 24 hours to effect the lock change. If the abuser is not a tenant, a survivor can provide a copy of a court order or of just a police report, along with their written request to have the locks changed. And upon receipt of that request and documentation, the landlord again has 24 hours to change the locks. If the landlord does not change the locks or does not change the locks within 24 hours, the survivor can go ahead and change the locks themselves. If they do that, they are required to use a similar quality or better quality lock And they must notify the landlord within 24 hours of them doing that replacement, that they've done it, and provide the landlord with a copy of the key to the new lock. Next slide, please. Another important California law protection is the right to break the lease agreement. Every survivor of domestic violence has a right to terminate a lease agreement as it applies to them individually, so that they can remove themselves from the abusive situation. In order to accomplish this, they must notify the landlord in writing that they intend to break the lease agreement. And they must attach proper documentation, which is a copy of restraining order, a protective order, a police report, or other documentation by a qualified third party. The documentation must be less than 180 days old. Once the survivor provides proper documentation and makes a written request, the survivor is only responsible for 14 days of rent. The survivor can vacate the unit and will only be responsible for the prorated amount of those 14 days. If the landlord re-rents the unit, like if the tenant survivor gives notice, they have 14 days to move, right? But if they actually move on day 5 and then the landlord re-rents the unit on day 10, then the landlord has to return that 4 days of prorated rent to the survivor who has moved out, because a landlord is not entitled to collect rent from 2 parties for the same unit at the same time when only one party is in possession. Next slide.
So next we'll talk about the right to protection from eviction for domestic violence survivors. So California law also provides survivors of domestic violence the right to protection from eviction. Unfortunately, it's unclear whether this law applies if the abuser is a tenant in the same unit. But generally, a landlord cannot evict a survivor or a tenant based upon an act of domestic violence or sexual assault, human trafficking, or stalking, or abuse of an elder or dependent adult. So similar to the right to break a lease, a tenant must have documentation by a qualified third party, a restraining order, or a police report that was issued within the last 180 days. It's important that a tenant asserts this defense if they get served with an eviction action, also known as an unlawful detainer. Again, we'll go over the eviction process in part 3 of the series, but just kind of a little snapshot. Once a tenant is served with a complaint, they have 5 days to respond in court, and a tenant may file an answer asserting all their affirmative defenses. An affirmative defense is a defense that's recognized by law that may allow the tenant to win and stay in their home. On the answer form, there is the ability to check multiple different affirmative defenses. So if this defense does apply to a survivor and they believe that they're being evicted based on an act of domestic violence or sexual assault, human trafficking, stalking, or abuse by an elder or dependent adult, then they should check that box in their answer to assert it. If they do not assert it at the answer, they may be barred from bringing it up later when they actually may have that defense. So there is an exception to this protection, and a landlord may still evict a survivor if both of the following conditions are met. So 1, the tenant allows a perpetrator to visit the property, or the landlord reasonably believes that the perpetrator poses a physical threat or interrupts the quiet enjoyment of other tenants. And the landlord previously gave the tenant a 3-day notice to correct the violation. So allowing the abuser to come to the property poses a risk to other tenants. So if the survivor seeks a restraining order within that 3-day period of receiving a notice, and enforces the restraining order by contacting law enforcement, then the survivor can still maintain this protection from eviction. Next slide, please. Another protection is the right to protection from eviction for contacting emergency services. A landlord can in no way prohibit, limit, or threaten to prohibit or limit a person's right to contact emergency assistance if a person reasonably believes that emergency assistance is necessary. There's no documentation needed to assert this affirmative defense in an unlawful detainer action, but any documentation like a police report, restraining order, or from a qualified third party would be helpful in successfully proving this defense. Next slide, please. Also, a housing provider does have a duty to maintain, to provide safe housing. This is a general duty for a landlord to maintain the property in a safe condition. So tenants may request simple improvements like better or more exterior lighting or changing to more durable locks on the exterior doors. Landlords who do breach the duty to maintain the property in a safe condition may be subject to civil liability. Next slide, nice. So next we'll go over hypo. So Tammy tenant has a stalker. She obtained a restraining order from the court. Her stalker continues to harass her by staying in the common areas of her apartment. Tammy frequently contacts the police. Her neighbors have complained to the property manager that the police come to the apartments frequently. The property manager then issues a termination notice based on frequent police activity. So true or false, Tammy has a right to be protected from eviction. Right, close the poll. So yes, the answer is true. Tammy does have a right to be protected from eviction. Tenants have the right to be able to contact emergency services, and California law imposes, this protection to make sure there's no chill effect on survivors contacting emergency assistance when it's necessary.
All right, I'm going to race through these last few slides, so bear with me because we're a little short on time. AB 1482 protections, just cause and rent control. AB 1482 is a statewide California law that went into effect on January 1st, 2020. It requires that a landlord have what's called just cause to terminate a tenancy. This law only applies to certain types of covered properties, which are specified in the law. For those covered properties, a landlord may not terminate the tenancy without just cause, as long as a tenant has lived at the unit for at least 12 months. And then the rent control aspect of this law is, again, if a tenant has lived in the unit for at least 12 months, a landlord may not increase rent more than 5% plus whatever the change in the cost of living at that area is, or more than 10%, whichever of those two figures is lower. And in any 12-month period. So yeah, a tenant cannot waive their rights to these protections under AB 1482, and any agreement to do so between the tenant and the landlord is void as contrary to public policy. If a unit is already covered by local eviction or rent control protections, the unit will remain subject to those local regulations. The statewide law does not remove or replace those tenant protections. The eviction provisions, next, I already said that sentence. A tenancy that qualifies for AB 1482 protections may not be terminated unless the landlord has one of the allowable just cause reasons, which must be stated in the notice that the landlord issues to terminate the tenancy. And just cause is sort of a legal phrase that is used to just mean one of the reasons that AB 1482 specifies that's allowed. There are two types of just cause reasons for eviction. They're at fault just causes and no fault just causes. So next slide, please. At fault just causes means the tenant is at fault. There are a number of reasons that the tenant can be evicted if they have, despite AB 1482 protections, they can be evicted for non-payment of rent, for lease violations, for committing nuisance, for committing waste, for refusal to enter into a similar lease agreement, for engaging in criminal activity, for assigning or subletting the unit in violation of the lease, for refusing to allow the owner to enter the premises, for using the premises for an unlawful purpose, or if the tenant gives notice that they will be leaving the property, leaving the premises, and then they fail to vacate at the end of the notice period, that is also an at fault just cause. And then if a tenant is an employee of a landlord and part of the conditions of their employment is that they get to live at this unit and then they are fired or let go for any reason, a landlord is entitled to evict them for not moving out after their employment ends. Next slide, please. No fault just causes. There are only a few. The landlord, these are reasons the landlord can evict a tenant even though the tenant didn't do anything wrong. The owner can allege that they are going to move into the property or an immediate family member is going to move into the property. And therefore they want to evict the tenant. The owner can say they're withdrawing the property from the rental market. The owner can announce an intent to demolish or substantially remodel the property in their notice, and that constitutes no fault just cause to terminate tenancy. Or finally, if the owner is complying with a government order to vacate the property, for instance, if code enforcement red tagged a property or something like that. Generally, tenants are entitled to relocation assistance under no fault evictions of either 1 month's rent or having their last month's rent forgiven. Also, just the fact that a lease is expiring is not by itself just cause to terminate a tenancy. All right, next slide, please. And this isn't part of AB 1482. This is a longstanding law. I just forgot to put a new orange slide up there. Security deposits. A landlord has 21 days from the day the tenant moves out to refund the tenant's security deposit. The landlord is entitled to deduct from that amount for damages that are beyond normal wear and tear, for cleaning fees, and for any unpaid rent from the security deposit. The landlord is obligated to provide an itemized statement of the deductions that they made and receipts for the services that they, for the cleanings or whatever they did to bring the property back up into its former condition. If they're withholding any of your security deposit. And that itemized statement and receipts are all supposed to be provided in that same 21-day period. If a tenant disagrees with the amount the landlord withholds, the tenant should consider writing a demand letter to the landlord. And if they can't reach an agreement, then the tenant may file an action against the landlord in small claims court. All right. Just under the wire.
Great.
Any questions?
And just to reiterate, our legal advice line phone number is on the slide, for any potential clients or prospective clients that want advice. Again, if clients aren't eligible for our services, we can still provide general information. But it's open Monday through Thursday from 9:30 to 1 p.m. It does come from a blocked if someone can't get through, they can leave a message and our legal advice line attorneys will contact them back. Just to let everyone know, the number that calls back that shows up is a blocked number generally, just to protect our clients who are survivors of domestic violence. So if there is a block number calling a tenant back, it could be from our legal advice line. And next week we will go over fair housing. It will be a presentation solely focused on fair housing, including reasonable accommodations, what's prohibited conduct, what housing discrimination, also source of income discrimination as well, from the newish laws. And the following week will be an overview of the eviction process.
Thank you both, Laura and Anna, for all of this information. And thank you all for attending today and asking your questions. We do have a few minutes if you have questions or if you want to come off the chat and verbally ask your questions. In the meantime, Joy is going to be dropping a feedback form. We'd really appreciate if you could take just a couple of minutes to fill it out. We look through all of those forms and it helps us really just tailor and better cater to your training needs. So we assure you, we read through them all very carefully and we make adjustments accordingly. Thank you so much.
Did see a question. Sorry, now I'm trying to scroll up.
The training
Ellen,
is at 9:30 today, and it's going to be the same time next week and the week after. So we're keeping the same time block. Yes, sorry, there was a question, I think.
yeah, so, well, now I saw another one. So if someone's conviction has been sealed or expunged, wouldn't it not show up on a background check anyway? So that is a very good point. It shouldn't, but there are some tenant screening companies that have it almost like a database of tenant information. And if it does pop up in there, it is unlawful for that information to show up in that credit report, but sometimes that can happen. But a landlord is not allowed to use any information that's been sealed or expunged in determining whether they can rent to that tenant.
I did see another one that was a little further up. When we see a landlord or property manager is breaking the law in one or more of their practices, what do you suggest we do? In my experience, simply telling the landlord, especially when it comes to tenant selection, often landlords do not seem to care or they argue that what they are doing is legal in their opinion.
Generally, what's best is to write a letter and anything in writing that outlines the conduct that they're doing, include the specific facts, how it's not in compliance with California law or maybe federal laws or any local laws, and have that paper trail to kind of show if they're not still complying after providing that letter, then there are maybe legal remedies depending on what the issue is. Tenants can either go to small claims court, tenants can contact code enforcement if it's a habitability issue. If it's a fair housing issue or housing discrimination, there is HUD and DFEH, so the Department of Fair Employment and Housing, to do housing discrimination complaints for enforcement. They can always contact a legal services provider as well to see if an attorney getting involved can help correct or remedy that issue. And then, is paying rent late a just cause reason a landlord can evict a tenant? Yes, but a landlord does have to provide a proper notice of non-payment of rent. And now we will go over COVID protections in the eviction process overview. It depends on what rent they are requesting. If it's rent prior to September 30th, a 15-day notice is required. If it's rent due post October 1, then a 3-day notice is required. And there is specific language that needs to be included in that notice in order for a landlord to evict a tenant. So the first step is always proper notice. Generally, sometimes landlords mess up on the notices, and that can be a protection for that tenants can use to prevent an eviction. Our legal advice line, it covers all our practice areas. So it covers housing, family law for survivors of domestic violence, immigration, again, for survivors of domestic violence or sexual assault or human trafficking, as well as consumer issues or public benefits issues. Maybe missing one, but it's in our previous slides. And then we also have some Spanish speaking legal advice line attorneys. We also have a language access line. So it doesn't matter what language the tenant or prospective client speaks, we can try to get a translator or interpreter on the line.
We are usually able to do that.
Yeah, language barrier shouldn't be an issue.
Well, thank you all. I want to respect everyone's time, but hopefully we will see you all next week. Thank you.